The state of Georgia is also trying to claim copyright on its own laws and saying that others cannot publish their laws. In most states, the official code, the official laws, are comprised of statutory text alone, and all agree that a state's codification, writing down of the laws in code, cannot be copyrighted because the authorship is ultimately attributable to the people. Conversely, all agree that annotations created by a private party generally can be copyrighted because the annotations are an original work created by a private publisher. In other words, we're talking about two different ways of presenting the law. If you've never seen this before, I'm not sure how easily I can show this to you, but the law will be, you know, Section 1, definitions, Section 2, the law, Section 3, maybe exceptions to the law, and Section 4, maybe some information about interpretation or ancillary things or whatever. The statute's annotated version will have extra information. It will have a summary of case law, or a summary of the way these statutes have been interpreted by the courts in case law, or it will have suggestions. You know, maybe a divorce section would have a suggestion that says regarding fault divorces. You know, fault divorces are now widely discouraged by most court systems. The court system would usually refer you to Section C or D. You know, in Pennsylvania, 3301 C or D for non-fault divorces. And that wouldn't be something that would be written in the section of the law, but maybe some third party like LexisNexis or Thomson Reuters has been hired to create an annotated version of that. And hired or not, sometimes they create an annotated version anyway, and they release that as their own book. So you can go buy the LexisNexis Georgia statutes annotated for a fee. And that's what was happening here. If you wanted to see the Georgia code, you could go on a website and you could be redirected to LexisNexis where you could read the code, but then this person wanted to reproduce the code, again, the laws, not computer code, wanted to reproduce the laws as they're written, and the official laws of Georgia are the annotated version. It's not that this annotated version is some private-only entity. Kind of like the Trump blocking Twitter thing, LexisNexis has become entangled, we don't know how yet, with the state, and their annotated laws are the state's laws.
Yep. That's exactly it.
The general rule that legislative codifications are uncopyrightable derives from an understanding of the nature of law and the basic idea that the people, as the reservoir of all sovereignty, are the source of our law. For purposes of the Copyright Act, this means that the people are the constructive authors of those official legal promulgations of government that represent an exercise of sovereign authority. And because they are the authors, the people are the owners of these works, meaning that the works are intrinsically public domain material and therefore uncopyrightable. Hence, how we can present all of this to you as well, is that all this case law and everything that we're reading is also uncopyrightable as having been created through the will or sovereignty of the people. Not any one person like a sovereign citizen, but rather the sovereignty of the people as a general whole. In particular, we rely on the identity of the public officials who created the work, the authoritativeness of the work, and the process by which the work was created. These are critical markers, where all three point in the direction that a work was made in the exercise of sovereign power, which is to say where the official who created the work is entrusted with delegated sovereign authority, where the work carries authoritative weight, where the work was created through the procedural channels in which sovereign power ordinarily flows. It follows that the work would be attributable to the constructive authorship of the people and therefore uncopyrightable. We conclude that the people are the ultimate authors of these annotations, As a work of the people, the annotations are inherently public domain material and therefore uncopyrightable. Because we conclude that no copyright can be held in the annotations, we have no occasion to address the parties' other arguments regarding originality and fair use. The code itself makes clear that these annotations are part of the official code, stating that the statutory portions of the code, quote, shall be merged with the annotations and are published by authority of the state, and when so published are to be known and may be cited as the Official Code of Georgia Annotated, or OCGA. The annotations were initially prepared by Matthew Bender & Co., an operating division of LexisNexis, pursuant to an agreement it entered into with the state of Georgia. Under the terms of that agreement, Lexis is responsible for the ongoing publication and maintenance of the code and all editorial, publication, and distribution costs. In exchange, Lexis was given the exclusive right of publication by Georgia. But notably, Georgia holds the copyright in the annotations in its own name. That's very notable. It would not be, again, at all illegal for Lexis to publish their own annotated code and charge for that. It's where Georgia is using it as its official code and saying that you can't even get to Georgia law at all without it. And since they've adopted it as the official code, now it's going to be an argument that you need to get to the annotated version since that's the official version. In addition to providing instructions to Lexis about how the annotations should be created, compiled, and arranged, the publication agreement establishes a number of other conditions governing the relationship between Lexis and the state of Georgia. Remember that state actor doctrine I was saying about before? We didn't go over any elements or anything, but basically a private person can become a state actor by acting on behalf of the state, by acting on behalf of the government. So listen to all these ways that Lexis has acted on behalf of the government. First, the agreement requires that Lexis create a free, unannotated online version of the code for use by the general public. Second, the agreement limits the price that Lexis can charge for the annotated code. While other commercial annotations cost as much as $2,570, the price of the OCGA is $404. Third, it grants Lexis the exclusive right to produce and sell print, CD-ROM, and online versions of the OCGA. Finally, it provides the Commission shall receive royalties on the sale of CD-ROM and online versions of the OCGA, but shall not receive royalties from print volumes. The publication agreement also provides that all of the contents of the code shall be copyrighted in the name of the state of Georgia, and the copyright shall cover all copyrightable parts of the code. This is important. This would be part of the analysis, any of this kind of analysis. Who exactly owns the license and who's the state actor and how did they get there? So this is all in Georgia's name and at the direction of the state of Georgia. So this is sounding more and more and more and more like Georgia did this and LexisNexis went along with it, rather than LexisNexis, really has some need to have a separate private thing, and Georgia is trying their best to produce a publicly available version and having no. Georgia seems to have adopted the privately commercial code and all that as their official code, which is weird because it doesn't need to be done that way. It almost seems like someone had a profit motive involved. And I don't like it when my government has a profit motive. The government shouldn't try to make its money from bake sales, is my opinion. Although certainly there's ways, there's a line there, there's a blurry line there. But on one side of the line, I don't think the government knows how to conduct a bake sale, and I'm literally meaning a bake sale. So I don't want the government focusing on that. Now, if the government has seized otherwise legal weapons, for example, or maybe weapons is not a good example, has seized otherwise legal vehicles from traffic stops that turned out to, where a person was stolen the vehicle, or it was being used for vast quantities of illegal drugs or something, and they otherwise legally seized the vehicles, and the vehicles are otherwise legal. Fine, I'm fine with the government auctioning off those vehicles. That's not what I'm talking about. I'm talking about the government going out of its way to get into a business that it has no business being in so that it can make a little extra money for itself, which is then often spent on the jobs of the people who are ordering those things to happen. Not alleging that here. I'm assuming some of that stuff personally, but I'm not alleging any of that here. I'm just saying the government isn't in the business of telling the public more about its code than normal. I mean, if you go around and read anybody's laws, they're pretty complicated but clear when you get down through it. This is extra. They're going this extra mile, and it's starting to approach my bake sale analogy, where the government is now getting farther away from governing so that they can have special laws that you have to pay for to see. That's a little weird. Public.resource.org is a nonprofit organization with a mission of improving public access to government records and primary legal materials. In 2013, PRO purchased all 186 volumes of the print version of the OCGA and its supplements, scanned them, and uploaded them to its website to be freely accessible to the public. It placed digital copies onto USB drives, mailed them to various Georgia legislatures. Additionally, PRO distributed copies of the OCGA to other organizations and on other websites in order to facilitate its further dissemination by other parties. The complaint came by Lexis on July 21st, 2015, seeking injunctive relief against PRO's widespread and unauthorized copying and distribution of the copyrighted annotations in the official code of Georgia Annotated through the distribution of thumb drives containing copies of the code and posting the code on various websites. PRO filed its answer in 2015, acknowledging its widespread publication, but denying that the state of Georgia holds an enforceable copyright in the code. They asserted fair use as a second defense. Finally, they counterclaim, seeking a declaratory judgment that there is no valid copyright in the state of Georgia because the OCGA is in the public domain. The district court granted the commission's motion for partial summary judgment, denying PRO's motion. The court concluded that because the annotations lack the force of law, they are not public domain. Soon thereafter, the district court entered a permanent injunction against PRO, enjoining it from all unauthorized use, including through reproduction, display, distribution, creation of derivative works of the official Code of Georgia Annotated. The injunction ordered them to remove all versions of the OCGA from their website. This timely appeal ensued. We review the grant of summary judgment de novo, which means brand new. They're starting over. There is no dispute that the state of Georgia has a registered copyright in the OCGA annotations, nor do the parties contest that PRO copied the OCGA in its entirety. At the heart of this case is the question of whether Georgia's copyright in the OCGA is valid. On this issue, PRO carries the burden of proof. Section 101 of the Copyright Act says, copyright protection subsists in original works of authorship fixed in a tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. As this provision makes clear, authorship is central to the statutory scheme. Only original works of authorship are eligible for copyright protection. What's more, authorship generally determines who has a possessory interest in a work. Copyright in a work vests initially in the author or authors of the work. Indeed, authorship allows a person to claim copyright protection regardless of whether the work has been registered with the United States Copyright Office. As we have explained, copyright inheres in authorship and exists whether or not it is ever registered. The meaning of authorship takes on special significance in cases like this, where we consider the copyrightability of a government edict. A long line of authority stretching back more than 180 years establishes that, with respect to certain governmental works, the term author should be construed to mean the people. The foundations of case law establishing this doctrine are far from clear. Few courts have fully explained the basis for this idea, and the Supreme Court last addressed the question in 1888. The Supreme Court first addressed whether a government edict can be copyrighted in Wheaton v. Peters in 1834. The court was interpreting the Copyright Act of 1790, but it did not explain the foundations for the rule of the law that was excluded from copyright protection. The court revisited the question in Banks v. Manchester in 1888 and held that the opinions of state court judges, just like Supreme Court opinions, were not copyrightable. In Banks, the court considered an infringement suit filed by a publishing firm that had published official reports containing the decisions of the Supreme Court of Ohio against a defendant who had published the same material in the American Law Journal. The plaintiff publishing firm in Banks was the chosen publisher, and in suing was attempting to enforce its copyright interest in the work of the Ohio judges assigned to it by the state of Ohio. The court found the copyright invalid. It emphasized that under then extant copyright law, only authors could obtain a copyright in their work. The court determined that the reporter who had created the compilations did not qualify as the author of the opinions or other materials written by the judges, since he had not created the works. Thus, the court rested its decision on a construction of the statutory term author that excluded both the judges and the reporter from qualifying as authors in the material in question, which in turn meant that neither judges nor the reporter could have conveyed a valid copyright interest to the publishing firm bringing suit. The next, and to date last time the Supreme Court considered the rule that government edicts cannot be copyrighted, came less than a month after the court had decided Banks, in Callaghan v. Myers, also 1888. The original publisher had obtained a proprietary interest in the reports from a salaried official of the state of Illinois whose duties, defined by statute, consisted of compiling the Illinois reports, organizing the cases, writing annotations such as headnotes and syllabi to appear alongside the opinions in the reports, and providing a certain number of copies of the final product to the Secretary of State of Illinois. The court began its analysis by reinforcing the basic rule announced in Banks that there can be no copyright in the opinions of judges or in the work done by them in their official capacity as judges. Nevertheless, it rejected the claim that the copyright in the Illinois reports was invalid. It explained that the underlying rationale of Banks did not apply, observing that there was no ground of public policy on which a reporter who prepares a volume of law reports of the character of those in this case can be debarred from obtaining a copyright for the volume which will cover the matter which is the result of his intellectual labor. The court thus reasoned that federal copyright law as explicated in Banks did not prevent the reporter from holding a valid copyright in the work, and that the state had not reserved the copyright to itself. As a result, the copyright the reporter obtained and conveyed to the publishing firm was valid. The compilation of judicial decisions and other explanatory material like headnotes, tables, indices was different from Banks in two ways. First, the reporter who had been appointed by the Illinois Supreme Court, and not the judges, had written the material accompanying the opinion, and second, the reporter and not the state of Illinois claimed to hold the copyright. The Supreme Court has not examined the doctrine since it decided Callaghan in 1888. Since Banks and Callaghan, the lower courts have further explored the nature and application of the rule. Thus, for example, the Sixth Circuit, in an opinion authored by Justice Harlan, applied the rule to state statutes in Howell v. Miller in 1898. The Fifth Circuit has extended the rule to encompass regulatory materials. Other courts have declined to extend the rule in other related contexts. One 1994 case declined to apply the rule to a privately prepared listing of automobile values that several states required insurance companies to use in calculating insurance payouts. Another declined to apply the rule to a privately authored coding system that was incorporated into a government reimbursement scheme through publication in the Federal Register. They declined to apply the rule to tax maps created by a county assessor's office, and declined to apply the rule to terms of a restrictive covenant a town entered into as part of a zoning scheme. It is worth observing that Congress has partially codified the rule announced in Banks. Specifically, the 1909 version of the Copyright Act provided that no copyright shall subsist in the original text of any work which is in the public domain or in any publication of the United States government or any reprint, in whole or in part, thereof. As the Copyright Office's 1961 Register's Report stated, even though Congress enacted a prohibition that only applies to the federal government, the judicially established rule still prevents copyright in the text of state laws, municipal ordinances, court decisions, and similar official documents. Although case precedent and congressional enactments have long established the rule that government works are not copyrightable, the foundations of the rule are generally implicit and unstated. Since the court in Banks was not especially clear about the legal source of the rule it had announced, and since the issue has not been raised before in our court, we start with a relatively clean canvas. What is clear, however, is that the rule enunciated in Banks was grounded on the court's interpretation of the term author in the Copyright Act of 1790, that works created by the courts in the performance of their official duties did not belong to the judges, and that public policy compelled the conclusion that these works were in the public domain and uncopyrightable. Thus, we understand the rule in Banks to derive from first principles about the nature of our law in our democracy. Under democratic rule, the people are sovereign, they govern themselves through their legislative and judicial representatives, and they are ultimately the source of our law. Under this arrangement, lawmakers and judges are draftsmen of the law, exercising delegated authority and acting as servants of the people, and whatever they produce, the people are the true authors. When the legislative or judicial cords are plucked, it is in fact the people's voice that is heard. Not surprisingly then, for purposes of copyright law, this means that the people, as the constructive authors, are also the owners of the law. And in this way, any work in which the people are the constructive authors is intrinsically public domain material and is freely accessible to all, so that no valid copyright can ever be held on it. The concept of popular sovereignty is deeply rooted in our politics, our law, and our history. The seminal statement of America's political creed boldly proclaims that governments derive their just powers from the consent of the governed, and I have not seen this before. They cited the Declaration of Independence, paragraph 2. That's cool. During the ratification debates that followed the Revolution, James Madison similarly began with the foundational idea that the people were sovereign and that the proposed form of government, the public voice, was pronounced by the representatives of the people. This is from the Federalist Papers number 10 at 77, which was written by James Madison. In fact, the United States reports are filled with invocations of the sovereignty of the people. Chief Justice Marshall explained the fundamental idea many years ago: the government proceeds directly from the people, is, quote, ordained and established in the name of the people, and is emphatically and truly a government of the people. In form and in substance, it emanates from them. Its powers are granted by them and are to be exercised directly on them and for their benefit. This is from MacAulay v. Maryland, 1819. While Banks is not explicit in grounding its holding in this conception of sovereignty, other federal courts have ruled that government works are intrinsically public domain material precisely because the people are sovereign and therefore the authors and owners of the law. In the same vein, and more recently, several courts have applied the rule announced in Banks and understood the rule to rest on foundational principles about the nature of law in a democratic society. Thus, in Wieck, a Fifth Circuit case sitting en banc confronted the question of whether a model building code, once adopted by 2 municipalities, lost its copyright protection. In concluding that the work was uncopyrightable, the court asserted as a basic principle of law that the law was in the public domain and thus not amenable to copyright, and that cases like Wheaton and Banks evince a broad understanding of what constitutes the law, so as to make judicial opinions in addition to statutes ineligible for copyright protection. On that basis, the court held that, as a governing law, the municipal building codes could also not be copyrighted. The court went on to explain that its holding rested on a deeper principle, a metaphorical concept of citizen authorship. The First Circuit has also emphasized popular sovereignty as being foundational to its understanding of the rule announced in Banks. After reviewing case precedent going back as far as Wheaton, a panel of the First Circuit asserted that the law thus seems clear that judicial opinions and statutes are in the public domain and not subject to copyright. In particular, citizens are the authors of the law and therefore its owners, regardless of who actually drafts the provisions, because the law derives its authority from the consent of the public expressed through the democratic process. The reason why judges and legislatures cannot copyright works they create was not because they are working for the government rather than for themselves, but rather because of a metaphorical concept of citizen authorship, which means that once it adopts the text as law, the body politic becomes the author of the work in question, leaving the original drafter with no proprietary interest. The ultimate inquiry posed by the rule in Banks is thus whether a work is attributable to the constructive authorship of the people, which is to say, whether it was created by an agent of the people in the direct exercise of sovereign authority. Statutes and judicial opinions are the most obvious examples of what falls within the ambit of the rule. This does not mean that statutes, judicial opinions, and other texts that carry the clear force of law are the only works subject to this rule. Summary texts are the kinds of works most obviously subject to the rule announced in Banks. Because statutes are prototypical works to which the rule applies, we rely on the statutory example as the lodestar of our inquiry. Put simply, there are certain things that make the law what it is. The law is written by particular public officials who are entrusted with the exercise of legislative power. The law is, by nature, authoritative. The law is created through certain prescribed processes, the derivation from which would deprive it of legal effect. Each of these attributes is a hallmark of law. These characteristics distinguish written works that carry the force of law from all other works. Since we are concerned here with whether a work is attributable to the constructive authorship of the people, these factors guide our inquiry into whether a work is law or sufficiently law-like so as to be subject to the rule in Banks. An analysis of these factors yields the conclusion that the annotations in the OCGA, while not having the force of law, are part and parcel of the law. They are so enmeshed with Georgia's law as to be inextricable. The annotations are themselves law-like insofar as we examine who made them, how they were made, and the role they play in the legislative and jurisprudential spheres of Georgia's public life. In consequence, they too represent a work, like the statutes themselves, that is constructively authored by the people. They are therefore uncopyrightable. First, and of critical importance to our analysis, is that the Georgia General Assembly is the driving force behind their creation. While it is true that the annotations were initially prepared by a private party, in this case Lexis, it is also the case that Lexis drafts the annotations pursuant to highly detailed instructions contained in the contract it entered into with the Code Revision Commission. Thus, by way of example, in addition to instructing Lexis to include annotations summarizing court decisions that are relevant to various statutory provisions of the OCGA, the publication contract tells Lexis which court decisions to include. Leaving even less to Lexis's independent judgment, the contract also instructs Lexis what not to include in the judicial summaries, ordering Lexis's editors to, quote, avoid long factual annotations where they do not bear directly upon the statute involved. Further, the agreement tells Lexis the order in which the various case annotations are to be arranged. In addition to providing detailed instructions that guide the creation of the OCGA annotations, the Commission acts in a supervisory capacity as well, monitoring Lexis's work throughout the process. Finally, the publication agreement describes in detail how the Commission is to give its final assent to the annotations. First, as for each type of annotation, the agreement affirms the Commission's role in approving Lexis's work. In short, the Commission exercises direct authoritative control over the creation of the OCGA annotations at every stage of their preparation. The Commission provides initial instructions to Lexis, directly supervises Lexis's work throughout the preparation process, and must give its final editorial assent to the annotations before they become part of the OCGA. In this way, the Commission undeniably controls the creation of the OCGA annotations. Further, confirming the Commission's deep connection to the Georgia General Assembly, the Georgia Supreme Court has held that the Commission's work is properly characterized as legislative in nature, and that it is therefore proper for the Commission to be largely composed of officials from the legislative branch. Indeed, the connection between the Commission and the elected legislators who make up the General Assembly is so close that the Commission may be properly regarded as one in the same with the legislators for our purposes. The basic intuition underlying cases applying the speech and debate clause seems to us equally instructive in identifying which entity in the Georgia state government is the creative force behind the annotations. The Commission is, in a real sense, the alter ego of the General Assembly, meaning that the creative force behind the annotations are Georgia's elected legislators. Acting through the Commission, the legislators closely supervise and direct the production of the annotation. The General Assembly actually votes and must vote to make the OCGA the official codification of Georgia's laws, and in doing so also votes to incorporate the annotations as part of the OCGA. That Georgia's legislators are in a very real way the creators of the annotations is a powerful indication that the annotations are subject to the Banks rule. To begin, it is apparent that the rule established by Banks that government edicts cannot be copyrighted as applied to the works of state governments is more limited than the statutory provision on copyright protection for works of the federal government. As we have explained, Section 105 states that copyright protection is not available for any work of the United States government, and that Section 101 defines a work of the United States government as a work prepared by an officer or employee of the U.S. government as part of that person's official duties. Thus, under this prohibition, that work of any federal employee made in his capacity as a government employee is uncopyrightable. By contrast, the rule in Banks is more circumscribed, applying to a limited subclass of government works. Thus, some works made by state employees that would be subject to Section 105 if made by federal employees are nevertheless copyrightable under Banks. As a result, the mere fact that a work was created by a state-paid employee in his capacity as an employee is not enough to trigger the rule in Banks. Something more is needed. Specifically, the government official must be entrusted with unique powers beyond those possessed by the typical government employee, such as the power to pronounce official interpretations of the law. In short, it is clear that the rule in Banks is not concerned, as Section 105 is, with the works of all government employees, but rather only with the works of certain government employees, which is to say, government employees who are possessed of particular powers, namely the ability to promulgate official binding edicts. Section 105's prohibition is justified on the grounds that the public paid for the work and is therefore entitled to access it, and because wide dissemination of federal government materials strengthens democratic discourse. On the other hand, the rule in Banks derives more directly from the concept of popular sovereignty. As a result, while Section 105 is concerned with any work created by a federal employee, since all government works are paid for by the taxpayer and as a policy matter are potentially useful to conscientious and informed citizen, the rule in Banks is concerned with works created by a select group of government employees because only certain public officials are empowered with the direct exercise of sovereign power. This explains why the state-paid court reporter acting pursuant to his statutory duties in Callahan did not run afoul of the rule in Banks and could hold a valid copyright in his work, even though the work he created likely would fall within Section 105's prohibition if he had been a federal employee. Though paid by the state and acting pursuant to his official duties, the court reporter was tasked with essentially administrative and clerical responsibilities, to wit, compiling and summarizing judicial decisions rather than the promulgation of binding legal edicts. There was, therefore, no ground of public policy standing in the way of his work's copyrightability. In contrast, the judges in Banks, when considered in their relationship to the sovereignty of the people, fulfill a different function than the court reporter in Callahan. Legislators and judges, unlike other government workers, are peculiarly entrusted with the exercise of sovereign power to write or officially interpret the law. Since the power to make law rests ultimately and exclusively with the people, the primary official duty of lawmakers and judges is therefore to act as agents of the people. In light of these considerations, that the Georgia General Assembly is the driving force behind and ultimately adopts the OCGA annotations is significant. Like the Ohio Supreme Court in Banks, the Georgia General Assembly is not simply composed of ordinary government employees, but rather of public officials whose official duties peculiarly include the direct exercise of sovereign power. This is not to say that every work produced by a legislative body is automatically uncopyrightable. However, because the OCGA annotations were created by public officials entrusted with sovereign legislative authority, just like the opinions and banks were created by justices of the Ohio Supreme Court entrusted with sovereign judicial authority, this weighs in favor of a determination that the OCGA annotations belong in the public domain. We are also persuaded because, while not carrying the force of law in the way that the statutory portions of the OCGA do, the annotations are law-like in the sense that they are authoritative sources on the meaning of Georgia statutes, having been merged by the General Assembly into the statutory text into a single unified edict and stamped with the state's imprimatur, and created and embraced by the same body that wrote the text that they explicate, the annotations have been suffused with powerful indicia of legal significance that is impossible to ignore. The nature of the OCGA annotations is spelled out in some detail by Georgia's General Assembly. While disclaiming any legal effect in the annotations, the Georgia law providing for the creation of the OCGA also states that the statutory portion of such codification shall be merged with annotations, captions, catch lines, history lines, editorial notes, cross-references, indices, titles, and chapter analyses, and other materials. This language is telling. In various dictionaries, the word merge is defined as combining or uniting, often in such a way that the constituent elements of the merger lose their distinct identity or characteristics and become one. The question then becomes, what is the nature of the new thing created when the Georgia General Assembly explicitly chooses to merge the annotations with the statutory text? Here, too, Georgia law supplies an answer. In particular, Georgia law provides that the merged text shall be published by authority of the state, and when so published shall be known and may be cited as the official code of Georgia annotated. The Georgia legislature was not required to merge the annotations with the statutes in order to create the OCGA, which it then stamped with the imprimatur of the state, but the bicameral legislature chose to do so. By combining these two components into a unified whole, their attributes have been intermingled and their distinct character altered. The statutory text, having been merged with these legislatively authored expositions on the meaning of Georgia law, must be read in pari materia with them alongside. The annotations combination with the statutes means that any understanding of the statutory text arrived at without reference to the annotations is axiomatically incomplete, because Georgia law tells us that the official codification of Georgia statutes contains not only statutory text, but also annotations that have been combined and unified with the statutory text into a single edict. A full understanding of the laws of Georgia necessarily includes an understanding of the contents of the annotations. In this way, the annotations are clearly laden with legal significance. Their significance is strengthened further by the legislature's decision to label the unified whole official. Indeed, demonstrating the importance of the state's decision to stamp the OCGA with its imprimatur, the first annotation in the first section of the OCGA favorably cites to a court case that warns that attorneys who cite unofficial publication of the 1981 code do so at their peril. Thus, while stamping the annotations with the state's seal and labeling it official does not suddenly elevate the annotations to the status of binding law, it too enhances their already potent cachet in a way that is undeniable and impossible to ignore. Moreover, as we have already noted, the annotations are not simply adopted by the legislature as an official reference work, but also in a very meaningful sense are written by the General Assembly, a fact that further accentuates their legal significance. Thus, it would be only natural for the citizens of Georgia to consider the annotations as containing special insight into the meaning of statutory text, and therefore confer upon the annotations special status. The nature and authoritativeness of the work, like the identity of the author, are material in determining whether the work is attributable to the constructive authorship of the people. After all, the decision in Banks not only emphasized the identity of the creator of the work, but also the name of the work, reasoning that the work was uncopyrightable precisely because it was an authentic exposition and interpretation of the law binding on every citizen. By way of contrast, a judge might create a work in his capacity as an employee of the government that bears little relation to his role as an official expositor of law. A speech delivered by the judge, depending upon the circumstances of the address, may or may not count as a work created by a government employee. But such a work assuredly does not count as a work made in the exercise of a sovereign power to make or interpret law. A judicial speech is assigned no authoritative weight. It binds no one and has no official effect on the law or how it is understood. Only those works that derive from the legitimate exercise of sovereign power, such as official interpretations of the law and the law itself, are assigned authoritative weight. Put another way, whether or not a work is assigned the authoritative weight associated with law is deeply intertwined with the question of whether the work was made by the agents of the people in legitimate exercise of delegated sovereign power. As a result, the authoritativeness of a work is probative on the question of whether a work is created in an exercise of sovereign power, and is also probative on the question of whether a work falls within the scope of the rule in Banks. Thus, in addition to whether the work was prepared by a judicial or legislative body, an examination of the nature of any work, which is another way of asking whether it carries authoritative weight, may indicate whether the work is uncopyrightable. These annotations carry authoritative weight and therefore make it more likely the work is attributable to the constructive authorship of the people. Quite simply, they are much closer to resembling the judicially authored materials found in Banks than other works produced by state employees, such as the materials produced by the court reporter in Callahan. It is also the case that the Georgia General Assembly voted to adopt the annotations as prepared by the Commission as an integral part of the official code. Further, it did so through a legislative act necessarily passed by both houses of the legislature and signed into law by the governor. Moreover, and significant for our purposes, the General Assembly votes each year to amend the OCGA and reaffirms its status as the official codification of Georgia's laws. This is so even when the legislature adopts as its own work a work authored outside the normal channels of the legislative process. Even when a government body consciously decides to enact proposed model building codes, it does so based on various legislative considerations, the sum of which produce its version of the law. In performing their functions, the lawmakers represent the public will, and the public are the final authors of the law. As we've noted, bicameral passage of a bill and its presentment to the executive are the only means by which a legislative body exercises the sovereign power entrusted to it. Similarly, the judicial power to propound the meaning of the law must be exercised according to established procedures. In short, as is the case with the identity of the creator of the work and the nature of the work, fundamental principles that govern how sovereign power is exercised under a republican form of government suggest that the process by which an edict is promulgated is probative as well on the question of whether a work was created through the exercise of such power. The importance of process was suggested long ago in Banks when the Supreme Court emphasized that only those works created by judges in the discharge of their judicial duties are uncopyrightable. Our inquiry has focused on whether the official annotations represent a direct exercise of sovereign power and are therefore attributable to the constructive authorship of the people. In making this determination, we have compared the work in question to works that represent the prototypical exercise of sovereign power, which is to say statutes and official interpretations of the law. We have been guided by three factors that may be regarded as the defining characteristics of law: the identity of the public official who created the work, the nature of the work, and the process by which the work was produced. When the wrong public official exercises a power delegated in the law, when the power is exercised of a type not contemplated by the law, or when the power is exercised outside the procedural channels prescribed by law, the act cannot be considered a valid exercise of sovereign power. From these principles, the corollary logically follows. when the action taken is of the type entrusted by the people to their agents, when it is wielded by a public official whose assigned duties include the exercise of sovereign power, and when it is exercised pursuant to constitutionally designated processes, it more likely represents an exercise of sovereign authority. The reasoning found in Banks also suggests the importance of these factors. All of them point strongly towards the conclusion that the OCGA annotations are not copyrightable. The OCGA annotations are created by Georgia's legislative body, which has been entrusted with exercising sovereign power on behalf of the people of Georgia. While the annotations do not carry the force of law in the way that statutes or judicial opinions do, they are expressly given legal significance so that, while not law, the annotations undeniably are authoritative sources on the meaning of Georgia statutes. The legislature has stamped them official and has chosen to make them an integral part of the official codification of Georgia's laws by wrapping the annotations and statutory text into a single unified edict. The Georgia General Assembly has made the connection between the two inextricable and therefore ensures that obtaining a full understanding of the laws of Georgia requires having unfettered access to these annotations. Finally, the General Assembly's annual adoption of the annotations as part of the laws of Georgia is affected by the legislative process, namely bicameralism and presentment, that is ordinarily reserved for the exercise of sovereign power. Thus, we conclude that the annotations in the OCGA are attributable to the constructive authorship of the people. To advance the interests and affect the will of the people, their agents in the General Assembly have chosen to create an official exposition on the meanings of the laws of Georgia. In creating the annotations, the legislators have acted as draftsmen giving voice to the sovereign's will. The resulting work is intrinsically public domain material belonging to the people and as such must be free for publication by all. As a result, no valid copyright can subsist in these works. Reversed in part, vacated in part, and remanded for further findings in accordance with this opinion. That's pretty cool. Learn a lot about how copyright works when it comes to government and laws.
That was awesome, man. It was great.
Oh my gosh.
Thank you for the highlighting there. That would not have been possible without that. But that is really interesting and very educational on how copyright gets its power. Literally going to the will of the people, the sovereignty of the people, is how both the laws and copyright get their power. And so you can't have a copyright on the laws or the incorporated annotations that are made by the legislature, even though, let's make that one part clear. The way that Lexis got into this was because the state had so clearly said, you've got to do it our way, and it's going to belong to us, and all that. If it had been done completely differently, where the state supplied the laws to Lexis, and then Lexis made an option, and then the state maybe put a link on their website or something, like, by the way, you can also buy the annotated versions, but the annotated versions were not the official versions, and not cited in court, and not had anybody say, you use these at your peril. You know, then the annotated versions would be separate, but they're not. They're incorporated, and don't use these at your own peril. And so that puts some teeth behind them, and that means that they're the official version.
Yeah, the thing I loved about this opinion is it's just so, like, something about the American essence of it. It's like, you know, I just can see the bald eagle fly in the distance as this opinion.
Yeah, oh no, that was definitely, like, there was some great stuff in there. They cited the Declaration of Independence.
That was cool. And I just love how, you know, they keep saying over and over again about the sovereignty of the people. And when I keep reading this stuff, it's like I just know where this is going in terms of the sovereign citizen stuff. It's like the proposition that people are collectively sovereign is uncontroversial. The fact that you individually are sovereign is a non-starter. These are not the same thing, but it's just like it's really, really cool because it's like it's just something very triumphant of, like, we the people have bound together in this collective exercise, and we have written this, and this is ours, and you can't take it from us. And I'm like, this is awesome.
Well, thank you for joining us. That is our show, everyone. I am Leonard French, your favorite copyright attorney, and joining us today has been Kurt Mueller, your favorite patent attorney. We have hit 100,000 subscribers. Thank you very much for helping us celebrate that. Thank you very much to our Patreon supporters. You can support the channel financially at patreon.com/ljfrench. At the $50 level in October, thank you to Jonathon, Doe, John Steele, Gavin, Barnard, Eevi, Andy, Kyle, Mudrak, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Grunkle, Tia Marie, Terry Crisp, Richard Fournier, Michael Jones, Spirit Bear, and Jan Negrey. And thank you to the $5 plus supporters who will be on the crawl and are scrolling on the LED panel behind me. So that is our show, everyone. Have a good one, and I will see you in the videos this week. I hope you all have a good week. You deserve it. Love you all. Bye.